Welcome back to the courtroom, where today's case takes a shocking turn. We're looking at State of Texas versus Devin Atkins, a case that starts with probation and spirals into something far more serious. Imagine being given chance after chance to turn your life around. Probation, treatment, support, but throwing it all away. That's exactly what the judge is dealing with here. But it's not just about missed check-ins. It's about mental health struggles, disobeying strict court orders, and even contact with a victim she was forbidden to reach out to. Stay tuned, because what begins as a probation violation soon escalates into a heated clash between the judge, the defendant, and the entire justice system. And the outcome? Let's just say you won't believe how quickly this courtroom drama explodes.
All right, ma'am, are you Devin Atkins? And Miss Atkins is on probation for the third-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, if the court would like.
Yep, I think I would.
Yeah, Mayor Cole, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as an adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devin Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her identifier?
Right here in the blue jumpsuit.
Your amended record reflect Ms. Cole has identified your probationer Devin Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court order?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do. Right?
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Meltdown Center in person.
Okay, and describe for the court what a TTM is.
A treatment team meeting.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself in the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and was that in violation of her probation order?
Here's where it gets serious. Probation is not optional. When you're placed under supervision, you're expected to check in, report your address, and follow through with community service. These rules aren't random. They're designed to help offenders reintegrate while protecting society. Yet Atkins repeatedly failed to show up, leaving her probation officer in the dark about her whereabouts. Think about that. If the system can't track her, how can they ensure public safety? This is where judges start losing patience, because missed check-ins don't just show irresponsibility, they show defiance. Viewers, what do you think? Should repeated no-shows be enough to revoke probation?
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry. I'm reading that one. No wonder everyone's looking at me.
I was about to say, I know, I was about to,
Community service. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address and so that you know where she is at all times?
Yes.
And if she does not do that, is it impossible for you to locate her?
That is
And
correct.
did she in fact immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court No, in conjunction with your testimony and your updated PS.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spindletop, and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services.
And here we see the deeper issue, mental health. Atkins was given multiple opportunities for treatment, but she refused to attend. Even worse, she kept contacting the victim in this case, despite a direct court order not to. That's not just reckless, it's dangerous. Judges take victim protection orders very seriously, because violating them often leads to reoffending. This is where the line between personal struggle and public safety collides. Should mental health struggles excuse repeated violations, or should the court crack down to protect the community? Tough question. Let us know what you think below.
Any questions about that? About the count? That's count 8 with the contact? Okay. Then at this time, based on the testimony, I am going to find count 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am, Judge.
Any additions or corrections to that report?
No, from the bench, Judge.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself for her.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that Spindletop MHMR may have, or any programs that probation deems appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity.
Notice the defense strategy here. They're leaning hard on mental health as the explanation for Atkins' failures. Her lawyer argues she was never placed on a mental health caseload and didn't get the support she needed. Now, that sounds sympathetic, but let's break it down. The court already made appointments, and she simply didn't show up. That's the problem. This isn't about the system failing her. It's about her refusing to cooperate. The defense is trying to frame her as someone who just needs more help, but the prosecution sees her as someone who wasted every chance. Which side do you believe?
I mean, it's hard when someone's not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. Did she go to regular Safe P or special? Hold on.
Special needs.
So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
At Spindletop.
That's what I'm telling you. That's not. I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath.
Wow, did you catch that? Atkins flat out rejects mental health treatment, even calling it psycho stuff. This is a critical courtroom moment because the judge is visibly losing patience. Think about it. If someone refuses to even be evaluated, how can anyone know what kind of treatment or punishment they really need? This isn't just disrespect to the court, it's self-sabotage. And here's the kicker. Judges often see refusal as a sign that rehabilitation isn't possible, which pushes them closer toward harsher sentencing. Do you think her defiance just sealed her fate?
Alfina, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just a runaround circle.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as,
I have one more thing to say.
okay?
She is not giving me the information needed to follow up with those type of things.
Okay, well, I don't
She
believe
doesn't have
you.
them.
I don't believe you.
You don't
Ms.
believe-
Cole would never say, go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health. And the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things
I was
that,
gonna die, so I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that.
This is the breaking point. The judge is ready to sentence Atkins, but she just won't stop talking over him. In a courtroom, that's a huge mistake. Judges see it as blatant disrespect. And in this case, the judge even warns her that every interruption could add years to her sentence. Imagine that. Your own mouth making things worse. This is where self-control can make or break a case. Viewers, be honest. If you were the judge, would you see her as someone worth giving another chance, or someone who's simply run out of them?
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered
I
against...
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you
You're talking
don't-
to the wrong person. I'm Devin Atkins. I don't have a gun.
I'm required to read that to
I
everyone.
don't know what you're talking about. I don't have a gun.
Good, then you don't have to worry about that. Go back with the bailiff.
And there it is, the gavel comes down. Devin Atkins, once given probation and countless chances, is now sentenced to 5 years in the Texas Department of Corrections for injury to an elderly individual. Despite every opportunity for treatment and rehabilitation, she chose defiance over compliance. The judge made it clear, this wasn't about denying help. It was about refusing to even try. Cases like this highlight a tough reality. How far should the justice system go to accommodate someone who refuses to help themselves? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, justice is spoken.